All right.
I
So
can
we are
hear
going
you.
live now on YouTube.
Fine. Okay.
Yes, sir. Good afternoon, everyone. This is Devashish Kumar Panda, co-founder team Lex Cognoscenti. I welcome you all on behalf of my team to this edition of Lex Cognoscenti's Rendezvous series. So before I introduce the eminent guest of this evening, I must tell you the purpose behind organizing this series. The basic vision behind this interview series is to facilitate and provide the legal fraternity with some invaluable anecdotes and escapades of several legal luminaries and doyens. And fortunately, we are joined today by Mr. Bharat B. Sawhney, whom we call BB Sawhney sir. We are joined by him today. So I would like to give a brief introduction of him for the convenience of our viewers. So Mr. Sawhney graduated in law from University of London in 1970, followed by his post-graduation in the same university in 1971. And he was also called to the bar of Lincolnshire. He taught law at Ealing Polytechnic, now part of Thames Valley University from 1971 to 1974, before coming back to Delhi at end of 1974. He enrolled with Delhi Bar Council in April 1975 and have since been practicing principally in Supreme Court and Delhi High Court. He was designated as senior counsel by the Delhi High Court in 2002. He was an advocate on record in the Supreme Court of India for almost 22 years prior to designation as a senior advocate. He has dealt with multifarious cases which deals with a number of laws including civil and constitutional law, arbitration law, service laws and banking laws. He has been a senior panel counsel for Union of India in the Supreme Court for several years. He has also regularly appeared for Cement Corporation of India, Jamia Millia Islamia University, ABN Amro Bank in most of their important matters. So I welcome you, sir, on behalf of Team Lex Cognoscenti to this interview session this afternoon, and we are really grateful and fortunate to be joined by you, and we are really looking forward to have a great session and great interaction with you. Welcome you, sir.
Thank you, sir. Devashish and Om Namah. Good afternoon to everyone. I prefer the Om Namah part. Yes, Devashish, let's, you can ask whatever you want on your agenda.
Sure, sir. So
It's a
beginning
pleasure
with,
to
thank
Yes.
you, sir. Pleasure is all ours. So, sir, beginning with the interview session, I would like to know about your childhood, your family background, and your schooling days. So, if you can tell our viewers on those parts.
Oh, that's a bit egocentric. Okay, about myself. I was born in Kenya, which is East Africa, in a small town called Kisumu, which by Indian standard was a small town because the total population of the town was 30,000. But it's the second or third largest town in Kenya. Was born there. I went to school there, my primary school and secondary school. That time we used to have senior Cambridge because Kenya, as you know, was a British colony. During school days, I was a naughty boy. I was nicknamed Charlie after Charlie Chaplin. And my teachers don't tell me, and my family tells me that I excelled in various spheres. Quite apart from academics, it was sports, drama, stage, that is acting, also dancing and various different competitions, including debating. I cleared my senior Cambridge. By that time, my father, who was a marine engineer and was employed there, he had retired, and he had already, along with the family, come to India and settled here in Delhi. I stayed behind because I still had 1 year of schooling to go. I completed that and came to India. I spent only about a year and a half, 2 years in India. when I completed my what is called advanced level. Advanced level is like almost like a undergraduation, and we call it a post school here. It's the 2 year period after senior secondary. You have the 2 year period, which they in England used to call advanced A levels. I completed that, got admission into University of London, London School of Economics, did my L.L.B, then my L.L.M, also from LSE, and was called to the bar, that is bar at law, barrister at law, in the year 1971. All this happened in graduation and post-graduation, and that happened in that period. I went there in 64. By 71, all this was over. And thereafter worked in a college teaching law for 3 years. And in 74, I came back. But I think we've missed out one part as to why I went into law. Well, when in Kenya, I found there were a lot of Asians there, a lot of Indians there. But they always used to speak ill about India. Although they loved India. They used to, on every vacation annually, they used to visit their families here. And but whenever they talked about India, it was in rather denigrating terms, derogatory terms. A lot of corruption, a lot of inefficiency, a lot of dirt, a lot of filth around. Then I got inspired. I said, something must be done about this, and we must put our country, our motherland right. And strange thing is that although I was good at science, physics, chemistry, physics was my favorite subject, maths was next. And my career master told me that I must go into, what he said was, you're a budding nuclear scientist. But my interest was elsewhere. In that, I looked at our leaders at that time, Jawaharlal Nehru, and I also found Gandhiji was a barrister, Jawaharlal Nehru was a barrister, Netaji Subhash Bose. So it somehow impelled me to go into this. I said, no, I want to do something for the government. That's how it all started, young blood and full of enthusiasm and patriotism. So that's how I went to London to do my law. And that's why I came back also. I was a British national. I had a UK citizenship. I still have my surrendered passports. I gave that up and took up Indian citizenship when I came here. Well, the initial experiences at the bar in India. Well, in fact, I also got married to Indra Sawhney. You probably heard the name Indra Sawhney versus Union of India. Yeah. I often say she's my better half in more than one way. She's better known than I am. We were both first generation lawyers. There was none in either family who had a career in law. And I was also new to Delhi because I'd spent most of my time either in Kenya or in UK. UK 10 years and in Kenya 16 years of my life, 17 years. So we were totally in the wilderness so far as legal practice and legal profession here was concerned. Except that my family knew one lawyer and her family knew one lawyer. That didn't really help. We did go there and see them, accompanied them to courts for a little while, maybe a month or two. But then we thought we must find our own way. We visited various courts, got to make friends with some people. And it turned out that a a law firm which was at that time a very well-known firm. You may have heard of Anand Das Gupta and Saga, predecessor of several firms, including J.B. Dalachandji. Anand Das Gupta and Saga, when after H.L. Anand became a judge of the High Court, it split into B.C. Das Gupta and Company and another 2 or 3 other companies, Lal and Company, I think. I'm not sure now. And then that split further. B.C. Das Gupta and Company also got dissolved, and 2 of the partners, one Mr. Ghosh and Mr. Bharati. I happened to meet them just while visiting courts, and we formed a small firm. There were only about 6 people, and that is when I can say that I formally started practice. That's about 1978. That is 3 years after. Now, in between, for a while, for about a year, you may have heard of Shamila Pappu, senior advocate. Shamila Pappu, senior advocate, was the first lady advocate to be designated by the Supreme Court. No? Okay. As a senior advocate. And M.K. Ramamurthy, senior advocate. We were very fortunate in having them as seniors for about a year, because we gained a lot of experience in drafting and assisting and research for the Supreme Court, for Supreme Court matters, and also High Court matters. And with that somewhat limited experience, I started as a partner in this small firm. That went on for about 5 years. Then after about 5 years, that passed off. That firm also split because it was decided, well, I decided that I wanted to start on my own as an independent counsel, arguing counsel. Well, that firm was called A.C. Gulati and Company. It lasted for 5 years. It was doing well. But then when I walked out, the others also decided to split. After that, we started in the High Court, in and myself. First, mainly in the High Court. She also had work in the Supreme Court. We then passed our advocates on record exams, I think 1980 or so. Oh, this is prior to even. Anyway. And yes, so far as professional work is concerned, I had at that point of time about 50% corporate work. Corporate work is what you do in the office, advisory work, a lot of banking work, drafting agreements, negotiation, assisting in negotiations so far as the legal aspect is concerned. And 50% was litigation. Litigation, I was always averse to criminal side because we had a very nasty experience when we were running that firm, A.C. Gulati and Company. We represented someone who had been convicted of murder in his appeal or special leave petition before the Supreme Court. It was a difficult case, and there was hardly any chance of getting any relief. And unfortunately, as it turned out, the special leave petition was dismissed. And this person, along with his 2 or 3 other colleagues, came that late afternoon to our chambers and said, "Dekho, एक गोली तो चल चुकी है, अभी एक और जलाऊं, एक और चल जाएगी." It was with great difficulty that we managed to pacify him and say that really who had been convicted by the High Court, by the trial court, and there was hardly any chance. He said, no, ये मैं चला दूंगा या फिर जो मैंने आपको फीस दी है और खर्चा दिया है वो वापस कर दो. we decided to refund his fee, and that was it. But even otherwise, you see, unfortunately, the police here in Delhi, and I think even other places in India, are not they are not maybe ill-equipped, or the investigation is poor, and then there is a lot of corruption. You have to keep the IO on your side, and if you want the IO to do something, then all kinds of gratifications and other things are expected. And the clients you deal with, as I said, generally I was not in favor, and that didn't suit my temperament. My temperament, I can't handle things which are of that nature. But yes, civil work, it is very hard work, needs a lot of research, needs long hours. And in the first 5 years of the profession, I recollect that we had to work sometimes up to 2 a.m., 3 a.m. in the morning, have the matters ready for filing, file them early in the morning, mention at 10:30, and then tell the senior, well, the matter is listed. So first few years is very difficult in the profession, both financially and otherwise. Otherwise, I mean, it's taxing because of the workload, and you have to do a lot more research because you don't have that much experience. There are new fields, and many things are new to you. Well, after that, after about 1983, I started on my own, or we started on our own. And within 2-3 years, I think we were well established. Thereafter, in the High Court, I had a lot of matters. She had a lot of matters in the Supreme Court. Often I argued the Supreme Court matters also for her, with her. And finally, in 2000, the High Court, at the time when I was doing a lot of writ petitions and appellate side work, earlier it was a lot of original side. They designated me as senior. And then after, I spent quite a lot of time in the Supreme Court, more than the High Court. Now, looking back, I thought it's now been 40. I had thought that I would slow down and retire at 70, but I extended it to 75. And now I've just crossed 75. And I don't think I'll be now winding down rather than trying to go up. That, in a nutshell, is what I've been through. A mixed bag.
That was quite interesting and great to know from you, sir, about your beginning phase and the way you described yourself in the first part. And as you said that you have not slowed down yet, so we know that the lawyers never retire. So, and even we see
Well,
you not to retire, keep us inspiring.
That reminds me, since you said some anecdotes, maybe interspersed, that reminds me. Remember Ram Jethmalani? He, I think not once, twice announced publicly that he was going to retire and not appear in courts anymore. So when he had said that, and a couple of days later, he was there in the Supreme Court trying to argue a matter. G. Ramaswamy, GR we used to call him. G. Ramaswamy was, I think, at one time Solicitor General. Very sharp counsel. The judges looked at Jethmalani and said, "We thought you had retired. We thought you were going to not accept any further briefs." And GR said, "Millards, a lawyer never retires. He only retires." He was retiring.
Indeed, sir. Indeed.
Yeah.
So, sir, now we would like to know about your law school and how was your experience in London University doing LLB and then LLM, and then you were barrister at law for a brief stint of time there. So, if you can tell our viewers about that phase of your life.
Well, I must say it was a great learning experience, not only academically, but also in life. It broadened my horizon in that I met persons of different nationalities, different religions. London is a very cosmopolitan city. You have persons from people and students, especially in the college. They were all East European, West European, uh, Africans, Asians, Chinese, and it broadened my vision and not only about their ways of thinking, their mannerism, but generally about humanity and life and the different colors and myriads of variations that we have and different ways of thinking and different ways they were used to. Like in England, one of the first things which shocked me was uh, an English friend of mine saying that she had borrowed some money from her father and she had to repay, therefore she must work. Now this for a student in India, you'd never think. It was so strange to me that I have to repay. I've taken a loan from my father, and I have to repay him, and I must work in the summer vacation to get that money. That- But there, it's the one normal principles of life. When you are 18, you are independent. Thereafter, you have to fend for yourself. The state took care of the education because they used to get education grants. You get a grant, and that you have to pay for yourself and maintain yourself and your own accommodation. The minute they are 18 or 20, they are out of the parents' house and they live independent. This was very strange to me in the initial stages. I have to pay my father back in Indian kind of milieu. It's very different. But yes, that broadened my vision a lot. And I did all kinds of things which I would not have done here in India. I am from a middle class family. There, uh, there is not so much distinction between. Yes, there is to some extent, but it's much diluted. Working class, middle class, upper class, not that much. It's far more diluted. So things that I would not have done here, I could do there. Go to big hotels, discos, have a lot of parties at home and go to other parties. We used to have in college, we used to call it because all the students used to have limited grants and limited funds. And I also had limited funds. So there, when you organize a party, it's called bottle party. So you have a lot of friends come, but each one brings a bottle. You have to carry your bottle with you and put it there. And there is only what is called punch. Punch is the house drink. There you put a big container, like a water canister type, and you pour into it the first 20 or 25 bottles which come. Beer is the base. So the host puts the beer in, and the rest put some wine, some vodka. So that drink was called punch, and that really gives you a punch. So when you enter and to get into the mood of the party, you have to first have that punch, and then come alive. All those kinds of things, various things which I would not have done here, I did there. And yes, it broadened my horizon. It opened up my mind. It be very broad-minded, understanding different religions, Christians, how they think and why they think and how they're so dogmatic about. Just like we have Hindu dogmatism and Muslim dogmatism, they have their Christian dogmatism. And like we have Sunni and Sunni, Sunni and the other one, get offhand. But they also have Protestants and Catholics, and at loggerheads with each other. Those things generally about life and about different nations and different ways of life, I learned. College there was flexible in that the lectures were not compulsory. Your attendance at lectures was not compulsory. So long as you did your assignments and did them well, and you cleared your exams, that was good enough. The same with Lincoln's Inn at the Bharat Law. The lectures were optional. I did attend a lot of I think most of the lectures at the London School of Economics. And there was a law institute there, which some London University lectures used to be held in a law institute. And there also, good assignments, moots, debates, we had to participate in, and I enjoyed. Lincoln's Inn, in fact, in Lincoln's Inn earlier, in all inns of court, there was no formal lecture. There were no formal lectures. They started only when I had gone there. About that time they started. The tradition was to attend what is called dining terms. A dining term is a period of about 3 weeks. And in those 3 weeks, you have to attend 3 dinners. And if you attend 3 dinners in a dining term, you have completed 1 dining term. And if you complete 12 dining terms, then you are called to the bar. That you were called to the bar. There was no formal education, because the idea was that when you go to dinner and sit with students as also practicing advocates, the inner bar and the outer bar and the students, all of them join in the dinner, and they generally talk about law and what happened in court and what is the case now and how we're going to handle it and so on. So that was the education they had. It was informal education of, in fact, very practical, about a lawyer who's attended court in the daytime, coming and having dinner with friends and narrating what transpired and how he handled the matter and what he planned to do the next day. So that is the education they had. It was simply attending those 12 dining terms, that is, having 36 dinners with students, outer bar and inner bar, and you are through. You become a barrister. That's how it used to be. Although when they had started these lectures, and we had to undergo the exams, part 1 exam, part 2 exam, and the final exam. So far as my inspiration, and see, I could have, in fact, a lot of people told me that I should stay back in England and either practice there as a barrister or continue in the academic field as a lecturer, because I was on the verge of becoming a reader then after that. I could perhaps have been a dean by now, I don't know. But as I said, what impelled me to come to India was that be in the bonnet I had. Um, at that time, I was very serious. And 74 was the time when, you remember the emergency and Indira Gandhi, the threat to democracy. That was the thing which really made me immediately decide to come back. I came in, the JP movement was then, Jayaprakash Narayan movement was at its peak. I came here, and before worrying about profession and so on, I went straight to Patna. And a friend of mine was with me. We both met Jayaprakash Narayan. I had the fortunate experience or rare experience of meeting him personally in that and sitting next to him. He was going to deliver a lecture or to address a meeting some 50 miles from Patna. And when his secretary told him that I have come from London, from Delhi, and to meet him, and I want to join the movement, he said, okay, come. And it was an ambassador car, the driver, I in the middle, and Jayaprakash Narayan on the left side. I was between the driver and Jayaprakash. We had a talk for about half an hour. And he said, I told him that I want to do whatever. I'm completely at service and I want to devote uh, my life to this. And he said, look, at this juncture, it's no point you staying here in Patna and doing work in the rural areas and so on. You don't even know their language. You won't understand what they are saying. If you go to court here and then you will hardly be understood. And the time is ripe for you to go back to Delhi, join the legal wing of the movement. There was an organization called the Citizens of Democracy organization, Citizens for Democracy, headed by V.M. Tarkunde, who was a retired judge of the Bombay High Court, very eminent counsel in the Supreme Court. So I came back here, went to see Tarkunde, and Amia Rao was the vice president, and one Mr. Jain, secretary. They had a executive committee of about 20 members. And used to sit in the Gandhi Peace Foundation. Gandhi Peace Foundation had become the center, the base for this opposition to emergency and the suspension of fundamental rights. So we had our office there, Citizens in Gandhi Peace Foundation, and we used to meet. And they took me on as an executive member. Now it worked well for a few months, but then slowly I found that the mainstream political parties, at that time the opposition parties, BJP, in fact, that is when the Janta Party was formed, because JP said the Janta must stand up. And the Nara used to be, slogan was, Indira Gandhi Sinasan Khali Karo, Janta aa rahi hai. Janta, that is how Janta word was came into prominence, and the Janta Party was formed. It was an amalgamation of the that time Jansangh, Bharatiya Janata Party predecessor was Jansangh. Jansangh and the others, local, and very of them combined and formed this Janata Party. And this Janata Party, in fact, took over. I call it hijacked the JP movement and people in the Citizens for Democracy were also sidelined. The real activists in the JP movement were sidelined, and the mainstream parties came, mainstream opposition parties. At the time, I think, various names are there, but let's not go into that. But I found that even within the Citizens for Democracy, there came to be divisions and ego problems and bickerings and so on. So I said, no, sorry, this politics and the politics, that kind of politics was not my cup of tea. By then, we'd also got a daughter. So I decided, no, now let me go back to, do only the profession, and let's fulfill our responsibility with the child and be content with that. So that's how I moved away from what I had initially thought I would do. In other words, I found the politics to be rather below the standards, moral standards I wanted to maintain. So I just walked out. Okay, I think that missing part has now been filled.
Undoubtedly, sir.
Anything else?
Yes, sir. Yes, sir. I have
By the
few
way,
other questions as well.
I may add now that though we started as first generation lawyers, both my daughter, Karnika Seth, now Karnika Seth, used to be Karnika Sawhney. Karnika Seth, she's a cyber law expert. She made her niche in that sphere and authored 3 books. She's also she was also given responsibility for framing the Supreme Court rules for e-filing and preparing e-filing and preparing the manual. He also does a lot of work for the Ministry of IT and addresses courses or attends courses and addresses police officers on investigation of cybercrime. Also, the Judicial Academy for judges and so on. So she's doing well. Our son also is a lawyer, advocate, and that's how I decided now I can take a back seat and relax for some time because now he's taking over. So the baton has been passed on to him. He's doing well too. Our son-in-law is also a lawyer. So I think that handicap that we initially had, they are fortunate enough not to face. But for first generation lawyers, yes, first 5 years is a struggle in the profession. But for youngsters who may be in the audience, I must say that law is very demanding, jealous mistress, as they say. You must be prepared to work hard. You can't be lazy. You must be sincere. You must be honest to the client, to the opposite side, opposite counsel, and to the court. Never try and mislead the court. Misleading the court may win you a couple of cases, but it will not stand you in good stead in the long run. It will sooner or later your estimation in the mind of the courts will be low, and the credibility will not be there. So if you want to be successful, you must be prepared to work hard, sincerely, and honestly. And first thing you should do when you get a matter or you get something, an assignment, is suppose you have the client comes and gives you a file and says, here is a bunch of documents. This is orally, he tells you something. First thing you must do is to arrange that file and arrange it in a chronological order. It is then that you get the flow and the sequence of events, and your intuition tells you now what is the true story. He may have told you whatever. Analyze and read every document, make your note, prepare a list of dates, which gives the flow. So that once you have done that, you don't need to repeatedly look at that big file again. And the secret should be to prepare a key. Your key can be 3 or 4 pages of this file, which is 500 pages. And sequence-wise, if you put down the document and its main feature and what is important for your client and for your case, make a note there. Well, that 500-page file, if it's not been paginated, by the way, first paginate it. And in your keynote, you can put the page reference there. And if you have original documents, don't paginate the original documents. Prepare a photocopy set, paginate that. That'll be your office copy. Okay. Get a mastery of the facts. That is important. That is the very base of the case. Once you've done that, you will know, well, now this relates to contract and lack of want of consideration or failure of consideration involved. You know the sections, you go there, then you look up the law, case law. Fortunately, you're very fortunate nowadays that you have so many aids which are online, SCC online and Manupatra and Law Finder and so on. But we used to have to dig into huge volumes. We used to call them digests. AIR manual is still in vogue. AIR manual, you look at the sections and you see the case law, make a note. We used to pull out volumes of the case laws and read them. Now you can just take out a printout or read them online. Very fortunate. But we used to have huge libraries. And apart from AIR manual, there used to be 50-year digest, quinquennial digest, 5 years, yearly digest. So if you have a point, you have to look at that section and that commentary in most of those volumes. And it took a lot of time. But yes, it got us into the discipline of hard work. And that, I think, is the reason why we could continue to work full time and properly, even till beyond 70s. What else? I think I leave it to you now. If I've left something out, you can probe me.
Indeed, sir. And while answering this particular thing, you have given a lot of uh, great pointers for young law generations, including the thing that we may lose a case, but we shouldn't lose a judge, and
Yes.
then how to go about with a brief. So I think this will help a number of law students, including me and our co-founder. He will be joining us soon. So thank you so much, sir, for this particular answer as of now.
You're welcome.
Uh,
Welcome.
so, sir, I was asking that as you said, you were a first generation lawyer and 5 years of initial days of practice is a struggle. So, I would like to know that what were the challenges that you have faced when you came to Delhi and joined bar in 1974, 1975. So, if you can tell any struggle, any challenges that you have faced then and overcome that.
Challenges. Well, one of my first visits to a lower court, Patiala House. At that time, it was, I think, the Delhi High Court was based there at that time, Patiala House. Sorry, not the lower court. I was walking down the corridor along with the colleague, and some client came, started talking to me, and wanted to ask something about his case. And I found a clerk, somebody's court clerk. He was walking by and he told that client, "अरे अरे इसके साथ क्यों बात कर रहा है? इसके तो client को कल फांसी हुई है." So that is the kind of challenge you have. It's unfair practices, and if you try and be what do I say, polite, or you can't survive in certain conditions. Now I found it very strange that somebody I had not even seen earlier, that court clerk I didn't know, the client I had just happened to start speaking to me and ask something. This kind of tactic put me really discouraged. One of the first challenges. But what as you go along, and if you persevere, you get an opening. How I got an opening was, as I said, I used to go to visited different courts. I met a couple of people, and then one of them happened to be an ex-partner of that firm that I told you had just got dissolved, BC Das Gupta and Company. So one of the ex-partners then started talking to me, getting to know me, know my background, and he invited me to his office. And he had just come out of that firm and wanted to start the new firm. And uh, a couple of queries came to us. We worked on them. He was happy with the work, the output that I had managed to give. And with that, we started off. He decided that I should become a partner, not merely a junior. We started and floated this partnership firm, and that is how we then stabilized. But first 5 years was a struggle, and I can tell you that sometimes I felt that I should go back to England. In fact, I even wrote back to the college that I was working, and they had happened to advertise in a vacancy. And I wrote to them and said, "I've seen this vacancy, but this is a lecturer grade 1 vacancy, is the lowest lecturer. I was a lecturer grade 2 and I was getting on to senior lecturership, which is equal to leadership. So could you upgrade this?" And they wrote back and said, "Yes, yes, please come, welcome." So I had this offer in my hand. But anyway, as things would have it, eventually I decided to stay back. Challenges, yes, sometimes you see, I had been spending more money than I was earning. Fortunately, I had some savings from England, so I could stand some part. But often the income were not even half the expenses. That's the struggle we had. And I and my wife had made it, Mrs. Sawhney had made it a point to try and not depend on anyone. We, in fact, started our career and without any office. We started with one rented room, literally one room, which was kitchen within that room, bedroom within that room, sitting room within that room, and 2 plates and 2 spoons, 2 cups. That's the kind of standard we commenced with. But God is great. I think hard work has. And we had this one principle that no, we must uh, be amongst those who have made their own stand, stood on their own feet. And that, I think, has given me a lot of satisfaction. That fortunately we've come up to a stage where our children don't have to go through this grind of 5 years.
That was great to know, sir, about your initial date struggle and the funnier or lighter aspect that you have said regarding Patiala House Court, which was the then Delhi High Court. So I hope nobody faces that situation in court in real in nowadays.
No,
So
I think that was the only time that I had that experience. Not after that. Uh, there's one more thing I must share. One must always be polite to the court. There are judges and judges. There are judges who are polite, who are sober, who are calm. They used to be saying sober as a judge. Unfortunately, my experience through the years, there are some who are sober, but many who are not so sober. A lot of things they say when patient as a judge and sober as a judge. A lot of them are impatient. And sobriety, I think, is beginning to lack. Not in all of them, but considerably. Also, but then you must be polite. Don't lose your cool. And don't raise your voice unnecessarily. Don't raise your voice at all. In fact, the only time I happened to in my young days lose my cool in court was when I had a matter where, see, my client had been, it was a service matter. My client had been selected for a particular post. And the result had also been declared. But he had not been appointed in the government service. And they went and decided to re-advertise that post. So I went to court, writ petition. The reason apparently was that there was some other candidate who the selectors wanted to appoint, but he had failed to apply in time or something. He had missed the bus. So I went to court, writ petition. The judges said, look, there is no appointment yet. Government is free to appoint or to not appoint. If they've decided not to appoint, you don't have a right. You don't have a right in a writ petition. Otherwise, you may or may not have a right. But you have no case. There is no appointment. You can't come. So we are going to dismiss. And they put the file down. I said, this is not only a matter of appointment, not appointment. The government is bound by the Constitution. They have to act in a fair and reasonable manner. They may not appoint for a reasonable cause. It's okay. But they can't just re-advertise without any. This will be violative of Article 14 and 16. They said, no, you have no case. So I said, all right. I took my file and I put it down, thumped it on the table, and I said, I know where to go. Lordship may do whatever you like. And I walked out. Out came the judge's peer. He had been sent after me. Come, judges are calling you. So I went back. Mr. Sawhney, yeah, we are wanting to dismiss this in limine, but since we had issued notice earlier, we have to give reasons. He said, yeah, kindly record those reasons, they'll help me. So when this was about to start dictating, the judge turned to the other side, said to Mr. Counsel, what is this? What are you doing? This is arbitrary. He's right. You gave him an offer. He's been selected. The result has been published. And now you're saying you won't appoint him. Right. He said, no, no, no. Uh, you take instructions. You need to cancel this. So next day, the council came and said, well, the government has decided that after a review of the matter, that he may be appointed, and my client may be appointed. So that's how, almost having lost the case, I actually got a relief. But that is, I think, the only instance when I actually lost my cool. Although it paid off at that time, in the long run, I could have done it better. Had I been, I would have done it in a different manner, although conveyed the same. But at that stage, with my young blood as it was, I think late 20s, I actually thrown the file down and told them, I know where to go. It means the Supreme Court.
That was a
Anything?
great anecdote.
Uh,
Yes, sir. So I have one more question to ask you, and then our
yes,
co-founder Jyoti Prakash will come in and he will ask something related to you in the second phase. So
very
the
well.
last question is that we know that you have appeared in Indra Sawhney's case with KK Venugopal sir, and in opposite against Nani Palkiwala and Dada Chandji. So we would like to know about them in particular and any other senior advocates at that time about whom you would like us to know, and any peculiar fact, any interesting way of their practice, any peculiar way of their presentation in the court that you would like to mention us.
Mm. I think, yes, the persons who impressed me were Nani Palkiwala, Soli Sorabji, Nariman. Nariman, I had the highest regard for. We used to call him bulldozer. The way he used to attack the court, but in a manner which was not offensive, but attacking, forceful. And he had that punch in his voice and make point and to repeat where emphasis was necessary. That is also another thing. After, if you have a good point, after a few minutes of argument, repeat that point. I read a book when the Learning the Law was one of the first books that they gave us to read in London. If you if you're strong on law, hammer the law. If you're strong on facts, hammer the facts. Repeat that fact after a few minutes. And if you are neither good at law nor in fact, hammer the table. So make noise. Uh, that is Glanville Williams' book, Learning the Law. About Soli, he used to glide. Very sharp, very pleasant, and but I think he was someone who could hold back some fact which did not quite suit him, but in a manner which would not show that he was misleading the court. He would just advert to it very briefly and then go on and hammer in the other point which was strong. He was a glider. He knew when to fly low and when to go high. Um, Apart from that, Anil Demania. I had a lot of respect for M.K. Ramamurthy, labor lawyer, senior advocate who, in fact, in his chamber, I was there for a year and a half. Extremely honest man. highly principled, trade unionist. He would fight and fight tooth and nail for justice. He did not. That was one of the few persons at that time who did not address the judges as your lordships, sir, or I'll show to you. I'll show to you. Never the lordships. He didn't believe in that culture of law like that. All equal. He used to work very hard, very sincerely, and no matter how long the case was and how difficult it was and how many days it took, he only charged 2 days appearance. And that's remarkable for a senior lawyer. Only 2 days appearance, no matter the case may go on for a year, because he said no. Labor and service matters where employees are involved. I will not charge more than 2 days, and I will not appear for the management. He never appeared for the management. I have a lot of regard for him, and I've tried to do my own little bit in that. Some cases, I think 10 or 20% of the cases I have handled as gratis or nominal. I think we must all do that, because there are cases where the person has a just case, but he cannot afford a lawyer. And we do this, then the satisfaction that you get is far more than you get in a paid. If something comes to me in the course of the interview, I'll put it.
Indeed, sir. Indeed, sir. And even the fact that you shared is also quite interesting to know from you. So now I would request Jyoti Prakash to come to the studio, and he will be asking you few other uh, important questions. And I would request our viewers to stay tuned with uh, Sawhney sir and Jyoti Prakash. This part will also be an interesting one. I am really sure about that. So, Jyoti Prakash, mic is all yours.
Jyoti, Om Namah.
Thank you.
Good afternoon.
Good evening, sir. Thank you, sir. Thank you.
Good evening. Good evening now. Okay.
Yes, sir. Thank you, Devasis, for asking so many relevant questions. And sir, it was really a pleasure to listen all the answers from you. Those were very delighting, and we learned a lot. And sir, with your permission, may I begin the second phase?
Yes, of course.
Sure, sir. Sir, you have mentioned about several doyens of the bar, like Mr. Ramamurthy and Soli Sarabji, Fali Nariman, Mr. Nani Palkhiwala. Sir, we also want to know about the legends of the bench. You have appeared before so many judges in so many important cases. So, do you find any interesting caliber or any interesting fact about some of the judges which you want to mention before us so that the younger generation should know who were the legends of the bar and also of the bench during your time and also in the recent times?
Hmm. Well, I've always had the highest regard for judges who are patient, who listen to you, who uh, are also learned and justice oriented. Some of the names Venkata Ramaya, Justice Rajendra Satchar, um, Justice Ahmedi also, yes, and Krishna Iyer also. I had a lot of respect for him. He was a leftist oriented mentally, but very, very learned man. V.B. Sawant Justice also. I forget names now, right now. Very famous Chota Sa Tha, Gujarat, when he started practice. I'm bad at names. I think my memory is little. But yes, judges who are sober, who are prepared to listen, and who are learned, justice oriented. Unfortunately, I think a lot of judges have now been appointed, or have of late been appointed, who lack the patience. I don't blame them that much because of the pressure of work. In the Supreme Court now, for instance, each bench would have some, on an admission day, 60, 70 matters, and they have to read those the evening before. So there's a lot of pressure on them, and therefore they perhaps try and hasten you. But then that does cost something so far as justice is concerned, because you may have a just case, you read the brief over 2-3 hours. You know that justice there is something to be considered in the matter. And when you go to court, the judge, unfortunately, my experience has been that patience has been sacrificed, or is being sacrificed. Justice is being sacrificed because of lack of patience. Sorry, the other way around. There are matters which should have been heard and point which should have been considered, but it's not considered simply because the judge says, no, sorry, and without your having said more than a sentence or two, the case is dismissed. But there have been judges who have said, yes, okay, we'll hear you, and then stuck to their point and said, no, so long as you get heard, and so long as you feel that the matter has been, the point that you wanted to put forward has been understood and considered, then you feel, okay, justice has been done. I thought there was a point to be in my favor. Judge feels not so. He has heard me and said, no, that's all right. So that satisfaction, I think, should be there, and that the client also should have the feeling that his case has been considered and dismissed. Justice Bhagwati was a judge who was very sober, very learned, and he was there about the time when we had started. The first, I think, 3-4 years in the profession, he was there. And he was always very polite, very patient, sober, and he gave very learned judgments and very well considered judgments.
Indeed, sir. Very right, sir. You have very rightly said that judges should be sober and they should be impartial, and all the persons who appear before court should be given impartial hearing. And the names you have mentioned all are legendary judges. We have greatest regard for them. We respect them and their judgments. And also my deepest regard to Indra ma'am. We could see her in the background. Uh, Good evening, ma'am.
हाँ जी बोलो.
It's really a pleasure to see you.
You wanted to see me, okay? I'm here. Before you.
Yes, ma'am. And say, we want to see you.
All right. Okay. So let Mr. Sani continue.
Yes, ma'am. Yes.
Yes, Jyoti.
Sure, sir. And sir, as we have discussed about the legends of the bar and bench, we now want to know about the important cases handled by you. We know that you have appeared in many important cases, like one of the first cases you have also appeared, where the ambit of Article 12 was decided, Som Prakash Rekhi, if I am not wrong. So we also want to know about all other cases, most important one, and the one which you consider as very satisfying or very close to your heart.
I think the important case I handled, one was Som Prakash Rekhi versus versus Bharat Petroleum Corporation. Now that was a landmark case in that it opened up writ jurisdiction and Article 12 also, 226 and 12, against government corporations. See, earlier, you could have a writ petition against government, of course. You could have a writ petition also against a government corporation, which was a statutory corporation, incorporated by a statute, like Indian Oil or Indian Oil Corporation, ONGC, and Life Insurance Corporation of India. They were considered to be state because they were controlled by the government, as also set up by a statute. So there was a limb or arm of the government. Now there was a corporation, Bharat Petroleum Corporation. It used to be earlier Burma Shell. And after nationalization, 100% nationalization, it became Bharat Petroleum Corporation. Now we filed a writ petition in a service matter relating to gratuity. I think it was Som Prakash Rekhi was the employee. And for the first time, the court recognized that not earlier it was said, it was thought that, well, it's a company. Bharat Petroleum Corporation was actually a company under the Companies Act, incorporated as a company, not by a statute. But 100% shareholding was of the government. The directors were appointed by the government because 100% shareholding. And the policies and principles, etc., controlled by the Ministry of Petroleum. So we said this is only a veil, transparent veil, that instead of having a statute incorporating by Act of Parliament, you're doing it under registration by incorporation of the Companies Act. This is too transparent a veil to not be amenable to writ jurisdiction. It is a arm of the government. It is a limb of the government. Whatever is being done is the act of the government. And we succeeded. And that landmark judgment opened up the field for writ jurisdiction against government companies also. Other than that, satisfying, there have been several cases. One of the satisfying ones, another one was not from the point of view of academic, but satisfaction otherwise, was a writ petition that I filed that we had appeared in Delhi High Court, appearing for a society called the Friends for Education. It was a PIL, and our grievance was that the Haveli, that is the bungalow, Haveli of Mirza Ghalib, located in Chandni Chowk, Bali Maran Chandni Chowk, was in a dilapidated condition. It had been ill-maintained. It had been encroached upon. There were squatters residing there, and even the famed his evening area where he used to sit and write his shairis and partake in his little get-togethers with his friends and co-poets. That was not being preserved. It was in ruins. So the High Court intervened. A commissioner was appointed along a three-member committee. In fact, they made me one of the parties, one of the members of the committee. Three-member committee was appointed. And we went there, found about 25 people occupying different areas and living there. There are utensils and beds, charpais all around. And the place was in a mess. So the High Court issued a petition, issued a writ to the Archaeological Survey of India and made them take over the Haveli. That Haveli is the persons who were there were given alternative accommodation, moved out. And fortunately, that Haveli has now been restored and restoration work also done, repair work done. And it is a landmark place where people go and pay their homage. That was satisfying. Academically, as a professional, as a lawyer, one of the most satisfying cases was the case of cyber or computer forgery. In that, there was a client who had come to us saying that he showed us papers that some opposite party, in fact, opposite party was a company, land development company, developers, the controlling person of whom was a practicing lawyer in Delhi itself. And he said this company is claiming that he had that company had paid him 1 crore rupees to him and to his brother and mother in cash, and had produced a receipt and filed a case in court for arbitration. Apart from producing a receipt, it produced some agreements. Signatures on those agreements and the receipt appeared to be that of our clients. But he said, no, the receipt, there was never any such receipt, nor did we sign these agreements in the form that they have filed in court. We had signed these agreements. The signatures are ours, but the main clauses there have been interpolated. See, what the other side had done was this. The other side, the company and its goons, had sought to interfere and dispossess our clients from our clients' lands, because they wanted that people are surrounding that area, other owners surrounded that land of ours, had entered into agreements to sell in favor of that company to develop the land. And this company wanted that our client should also sell this land, but he had not agreed. So while those people were trying to interfere, our clients had filed suits, 3 suits, different suits on 3 different occasions, trespass, etc., encroachment, and so on. Eventually, there were negotiations, and there was 3 suits we agreed to withdraw. This agreement for withdrawal of the suits was entered into. The papers were prepared by that lawyer who headed that opposite party company. And there were three innocuous clauses there. Main principle being that we will withdraw the suits. Now there is no dispute pending. We have settled our matter. Full stop. Now, in these agreements, my computer copy paste or whatever, however they did it, they interpolated and superimposed clauses saying that they had paid 1 crore as part of the deal for our clients to sell the land to that company. Our clients had then subsequently also at the time executed a receipt at the time of payment. And in this receipt also it had been recorded that if our clients back out, then they will pay 4 crores to the company as its profits. Now these signatures on these photocopy agreements that they had, our client said appear to be theirs. If receipt also photocopy produced appeared to be our client's signatures. I studied that matter in depth, analyzed and expand with lens and what do you call it, expanding the letters font. I found that there was minute differences in the margin. Margin where the sentence starts. And in the paragraphs of the clauses where the interspace, where the spacing is there, in the original, there's a lot of space had been left in. The photocopies produced filled those, both in the original, filled these open spaces, the blank spaces, by putting in new clauses which said 1 crore has been paid in cash. We have now decided not to go ahead, and we will now pay them. If we decide not, 1 crore we have received in cash, balance will be paid on such and such a date. If we back out, then 4 crore to be paid to them. Virtually what had been put in the receipt. Now these signatures at the bottom of each page of the agreements, and there were also affidavits taken to the same effect. Those were lifted and put on, receipt was created and those were copy pasted on the receipts. Therefore, I pressed very hard. There was an arbitration clause in the agreement saying that the company shall have, company's lawyer so-and-so, not the company's lawyer, sorry, so-and-so lawyer named in Delhi will be the arbitrator. So the arbitrator sent a notice to our client, and that's how the client came to us. I looked at it very minutely, and I said, no, though the signatures appear to be theirs, and we must ask for the originals to see how they have interpolated this. So the originals, eventually the matter came to the High Court because we moved a petition in the High Court saying that the arbitrator should be removed. He is misbehaving. The High Court asked them to file the originals. When the originals came, those I looked at very, very carefully, inspection and so on. And I found that there is very minute differences in the margins. And the spacing between clauses was not uniform. It was not the same after each clause. It varied somewhat. So I said, this is interpolation, because the photocopies that our client had of the agreement that was actually entered into, when you placed, one over the other, you find that everything matches so far as the clauses which were originally there they were there also in there. But in the copies that we had, those interpolated, inserted, superimposed clauses were not there. But the opposite side case was before the court. Look, we have deleted the clauses which were there from the original, taken a photocopy and produced in court. Our case was no. The originals were in fact as they were in the photocopies that we have produced, and these additional clauses have been added by printing in the original itself by this computer manipulation. Now, one more interesting fact here, and that is where I had to work very hard. Our client's lawyer at that time, when the compromise was entered into, had simply withdrawn the suits. Thereafter, when a notice had been sent by the opposite party to our client making this claim, that lawyer, or rather his clerk, because that lawyer had passed away, filed our photocopies in court, saying in that very suit, after the matter had been disposed of, he filed. But with a back date of the date of the withdrawal of the suit. So this should not have been done, but anyway. The opposite party apparently, and look at this, the opposite party apparently took into confidence that court staff, substituted the photocopies that our client had filed with photocopies of their own agreements, which had these interpolated clauses, superimposed clauses, making this claim of 4 crores. So this is the situation we were faced with. Then I had worked very hard and I insisted, and I told, eventually the High Court appointed an arbitrator, neutral arbitrator, independent arbitrator. Before the arbitrator said, now what is there? It's a matter of court record. Your client, that is my client, has himself filed agreements in court which are against you, and these agreements tally with what the opposite party is saying. So I had to insist, and I said, no, they have manipulated matters. They have taken off those from the original record of the court, and this kind of manipulation is not unknown. And I fortunately found, and that is where I had to work very hard, at least 10 reported cases, even in the Supreme Court. 2 or 3 cases were of the Supreme Court, where manipulation had in fact been done in the court records, and strictures had been passed against the staff and whoever else, even lawyers. So I said, if this can happen in those 10 cases, surely you must investigate whether this has happened here also. And fortunately, the arbitrator eventually turned, and we were asked to provide a list of 6 labs, forensic science laboratory labs, 3 from their side, 3 from our side. And I said, let the other side appoint from my list anyone. They went for the Delhi government forensic science laboratory. I said, you appoint anyone, either the arbitrator appoints anyone. Eventually, after a long time, the report came. It was in a sealed cover. The opposite side apparently had already found that the report was against them, or had the intuition that this would be against them. And after having fought the matter for 4 years, tooth and nail, they came to the court and to the arbitrator and said, kindly don't open this thing. We will withdraw the case. And they withdrew the case. The arbitrator said, no, since we've called for the report, all right, you withdraw the case. Then the case was withdrawn. They said they have no claim. Made that statement, case was over. The arbitrator said, since we were asked for this forensic science laboratory report, and it has been produced before us, let us see what it says. And it said exactly what I had argued, that this was computer manipulation, although in the original itself, these clauses were there on the face of it, and they appeared to be part of the thing, and the signatures were indeed of our clients. These incriminating clauses, or rather clauses which had imposed this liability of 4 crores on us, and that receipt of 1 crore had been superimposed and had been added on later, and it was not there in the originals. That was extremely satisfying. And that, by the way, is one of the cases where I charged nominal fee. That made me all the more satisfied. It was a long narration.
Indeed, sir. That was quite interesting to know from you. And we also learned that you still conduct cases, 20% of your cases pro bono. And that is very inspiring that a senior advocate of your stature conducts so many cases pro bono and provides so many legal assistance, so much legal assistance to the society without any cost. That's quite inspiring, sir.
That is necessary for everyone to do, and it's not. It is, in fact, for my own satisfaction. I feel happier when I do this. So it's not being. I am being selfish because this is for my own satisfaction. And if you do something for your own satisfaction, I don't think. And that's whenever when somebody says thank you for something which I have done out of my own pleasure, I say no thanks is necessary. I need to thank you for giving me the opportunity to be satisfied. So it's one's own peace of mind, satisfaction, and you feel good that you've achieved something for somebody, and it works both ways. Is not everything. To be at peace with yourself and with your conscience and to feel happy within is worth much more than any amount of money. That, I think, is something I've learned over the years. You're not doing fulfillment is not only money.
Right, sir. Right, sir. Satisfaction is the paramount thing that we should strive for. That is quite, sir. And said that we have dealt with. Yes, sir. Sir, we have dealt with so many aspects of your life, your career, and the important cases. Lastly, I want to know what are the most important reforms you want to see in our legal system, both in legal profession as well as in the judiciary?
Improve our code of civil procedure. CRPC and CPC, they need actually to be overhauled to make it simpler. The stages of, we have all the provisions, but the way they've been put into practice or are not being put into practice, it creates all the problems. So we need to have clear-cut stages, like you can have, instead of the court doing most of the part of the litigation, you can have, in fact, in the Delhi High Court, they've started, and they've had for some time, judicial officers and joint registrars. But the joint registrars are mostly being given non-contentious delegation, complete window of parties, LRs, and acceptance of bank guarantee and things like that. Fortunately, for I think 3-4 years now, 5 years, recording of evidence on the original side has also been entrusted to judicial officers. joint registrars. I think joint registrars who are judicial officers can be given much more powers of admission denial, etc., is also being done by before judicial officers. But apart from that, interrogatories, statements under Order 1, Rule 10, preliminary statements, even in England, in fact, mediation and pre-trial stages they have before the court master. And the court master, and before the court master itself, half or more than half, I think about 70% of the cases get settled because of they're acting as mediators and conciliators. We do have mediation conciliation cells here also. In commercial matters, but there it's a compulsory thing which has to be gone through. So if the judicial officers, joint registrar, etc., are given not only these non-contentious powers and also powers to record evidence, but in addition, if they play this role of preliminary statements of parties at the initial stage before the trial, and then see where the difference is, where the difference lies, narrow down what is required to be actually tried, narrow down the differences, go in for discovery, inspection, file all the, and warn the parties that if all documents are not produced at this stage, no further documents will be, and this will be the confines that you will have to stick to. And then narrow down, apply their judicial mind and narrow down the difference and send only the really contentious residuary matter to the court. Then I think we will have faster disposals and not only faster disposals, even in that narrowing down process, more than half the litigation will be sorted out and resolved by compromise and conciliation. At present, we do have mediation conciliation, but it's either voluntary or preferred by the court, or in commercial matters, consent is sought, etc. But that, I think, pre-trial stages need to be strengthened and made compulsory and not merely voluntary. And if that happens, I think at least the original side, only 25% need to go to court before the judge. That would be one. So far as the profession is concerned, I think now with 5-year courses and 1-year training and so on, that is already being strengthened. I don't think we are actually the younger generation lawyers, I find, are very competent as compared to what we had at our stage. See, earlier, law used to be a profession which one took up if one couldn't get anywhere. If you didn't get admission in an engineering college or couldn't be in medicine, then all right. You couldn't be an architect, then you okay, chalo theek hai, residuary law to hai na. So law was not looked at as a profession where intelligent, able people would opt for. But now, fortunately, there is a change, and we have very intelligent and bright people taking up the 5-year courses and doing very well. And when they enter the profession also, I find them well up the mark. I think in our times when they started, people had hardly read Bare Acts, and Bare Acts and those key books were the only academic background that entrants had.
Very rightly you have pointed out, and the recommendations that you have made should also be implemented so as to strengthen our legal system even more. And so, lastly, it is the last question of this particular session. I would like to know from you whether do you have any regret in your life? You have done so many cases, you have worked with so many legendary figures, you are a legend yourself. But after all, do you have any regret in your life that you couldn't do something and you want to do that for sure?
Yes, I think I now feel that instead of litigation and fighting cases in court, contesting matters, I would rather spend my time a little more peacefully and constructively in mediation and conciliation. And that is one thing I intend to participate in actively. Uh, no, arbitration I've done already enough. That's contentious. I would like to do, I think, mediation and conciliation and try and settle matters before they get into court. A lot of things can be sorted out if proper attention is paid. And in one of the experiences I had was matter was referred to the mediation cell. The two sides came. Uh, that time I was not a mediator. I happened to be representing a party, a big company. And the other side was also a big company. So they had their ego problems. When they came, the mediator who was there said, okay, both the counsel go out. Let the clients talk. I will keep quiet and listen to them. So the mediator asked them, what is the problem? They'll tell each other. You tell him your version, you tell him your. You would tell each other your respective versions. So they did. 10 minutes later or 15 minutes later, the mediator called us in. He said the matter is settled. I said, how? They were so entrenched about their respective stance. He said, no, the problem is the problem was their ego. They were both big companies, big managers. They didn't want to talk to each other and give in. Now that they're on the same table and sitting together, and I am there in between, they've settled themselves. I didn't even make any effort to settle. I just said talk to each other, and they did. Matter is settled. So that is what I would like to do, to make people sit together, exchange views, and nudge them wherever necessary. Tell them which is the weak point of your case, and tell the both sides how their respective cases is weak on what aspect. And say, why not settle it now? Why wait for 20 years and have this bad planning? That I think is one area which I have done some matters. In fact, in one matter, which was a family dispute property matter, not one, I think more than one. Big families also. And a contentious, not two-way fight. It was a kind of 5 different cross attacks, one brother against another and 2 brothers against the third one, and like that. And I talked to them. I was representing one group, and they came, the other side lawyer, because I happened to be a designated senior. He came, approached, and said, "Why don't you try and mediate and settle?" And I think I must have had about 20 meetings, very contentious, a lot of noise in my chambers when they used to come. There were fights, not physical fights, but quarrels with very high tones. But eventually, with great effort and suggestions and many multifarious solutions suggested, it got set. And the council and the other parties was very considerate, or not considerate, appreciative. We drew up the compromise and filed it in court. And he said to the judge, a word of appreciation for Mr. Sawhney must be recorded because he has spent a lot of time and without charging anything and achieved something which nobody else could have done. So the judge recorded that and recorded also a note of appreciation. So that gives you a lot of satisfaction. But if you can prevent such cases, then I think and this is adopted as a conciliation, mediation, as I said, pre-trial stages. If there was going to be strength of mediation, conciliation be made compulsory, at least for a limited period of 3 months before litigation, like in commercial matters. And I think litigation this could help us reduce the docket of the courts and the delays which are there. Of course, there are vacancies to be filled. There's always a backlog of vacancies that should be expedited also. Oh, I think we've already had a long session, haven't we?
Right, sir. So with this, we have gone to the end of this session. It was really a pleasure to have you. We have learned a lot. You have described very lucidly about your childhood days. Yes. And how you came to India during the emergency and how you joined JP, the great JP, Jayaprakash Narayan. And after that, how you joined the Delhi Bar and how you conducted all the important cases. And also, we had the opportunity to meet Indra Sawhney ma'am. We are grateful to you and ma'am for this great session, sir. We have learned a lot and we'll treasure this session forever. And it will always remain in YouTube for the benefit of all the younger member of the bar and also the senior members who want to watch us today and also in the future. We are grateful, sir. We are privileged and we are exhilarated to have you. And we will definitely look forward to have you again in our show. Thank you, sir. We are grateful.
Thank you. Thank you, Joe. It's been my. Okay, thank you.